Thank you, Your Honor. May it please the court. The 6:30 p.m. docket for Tuesday, March 10th, 2026 consists of one case. Appeal number 126167, State of Kansas as the Kansas Highway Patrol versus $381,620 in U.S. currency, and Bryce Robert Fuleki, a case out of Saline County. Counsel for the appellee petitioner has requested 3 minutes for rebuttal. Counsel will enter their appearances.
May it please the court, Assistant Solicitor General Ryan Ott, appearing on behalf of petitioner appellee State of Kansas.
May it please the court, my name is Julie McKenna. I'm appearing on behalf of $381,620 in currency, as well as Bryce Fuleki, along with Seth Krell, Pro Hoc Vice.
Good evening, Justices. I'm Seth Krell. I, too, am appearing with my colleague, local counsel, Ms. McKenna, on behalf of $381,620 in U.S. currency, and Bryce Fuleki.
Thank you.
Chief, we're ready to proceed.
Okay. Counsel, if you would approach your counsel tables, and then we'll commence with oral argument.
May it please the court. A basic principle in the law is that a party must have standing in order to participate in a case. The district court here recognized that fact in finding that because KSA 604111A requires a party to either be an owner or an interest holder of the property that is being seized and is being forfeited, and because Fuleki did not make any claim in his amended claim to being an owner and interest holder, and because he affirmatively waived any such interest in his in his disclaimer, which the court found to be voluntary, that he lacked standing and the district court properly struck his claim. We're here because the Court of Appeals inverted that process, instead holding that before the district court can consider whether Mr. Fuleki even had standing to participate in this case, it should have instead decided the constitutional issue of his suppression motion, whether the searches or seizures violated the Fourth Amendment. We'd ask this court to correct this inversion and to do so with a simple holding. Standing is something that is decided first, and if a party lacks standing, that party cannot participate in a forfeiture proceeding, including challenging the search or the seizure.
Counsel, would you agree with me that the standing determination is often, and certainly in this case, based on a factual determination by the district court?
Yes.
And I assume you would also agree that the only way a district court can properly reach a factual finding is through the hearing of evidence.
And the district court held an evidentiary hearing here,
And
Your
so
Honor.
I guess my question is, setting aside, at least for the moment, sort of the constitutional overlay, why isn't the suppression motion effectively just a challenge to the admissibility of certain evidence?
Well, a suppression motion, I mean, it was a challenge to admissibility.
And so typically, before a district court can make a factual finding, it has to receive evidence. And before it receives evidence, it has to rule, if challenged, on the admissibility of that evidence, correct?
Yes, Your Honor.
So why shouldn't the district court have to consider the admissibility of the evidence first before reaching the standing finding?
Two responses, Your Honor. First, standing is jurisdictional under subject matter jurisdiction. It must be decided first. Second, the district court did hear evidence here. It heard evidence towards his voluntary disclaimer and towards the interview that he had with the Highway Patrol, and it made a determination that that was voluntary. And so The district court did hear evidence on that issue, which I think is related, but is also separate and distinct from the suppression motion, which challenged specifically the two stops. The first stop originally for its length, and then the second stop.
Yeah, basically the individual is saying, in effect, you considered inadmissible evidence. Is that a fair characterization of their argument from your point of view?
I just want to clarify, are you talking before the district court, or are you talking
the district court considered inadmissible evidence.
I don't think that's a fair argument in the fact that they challenged the stops, not the voluntary disclaimer.
Well, you might have a substantive claim that the evidence actually is admissible. What I'm trying to get at is figuring out whether the district court ever actually decided that question. The question of admissibility.
It decided the question of admissibility as it pertained to the voluntary disclaimer, and found that it, coupled with the fact that Mr. Fuleki's amended claim contained no actual claim of ownership, showed that he is not an owner or an interest holder under 4111A, and thus has no standing to even file a claim. And for that reason, sorry, Justice Rosen.
No, thank you. Didn't the part of the purpose of the motion to suppress was to challenge the validity of the waiver that was ultimately entered into, and then the district court relied on the waiver that he was trying to suppress. It seems just kind of counterintuitive, or just basic. It's kind of what the Court of Appeals did. It just seems wrong that he can't challenge the very document that the district court found was valid. Why can't he? There's no mechanism if there's no standing to challenge that.
To be clear, Your Honor, he did not. I'm sorry, I have a bit of a feedback.
No, go ahead. Yes, still challenge.
To be clear, Your Honor, he did not challenge the voluntary waiver. He challenged the stops. I know the Court of Appeals in its opinion mentioned that he brought.
How does he get to the challenge of the waiver then?
Two responses. First, as it applies to the suppression motion, he could have argued that it was involuntary. He chose not to, for whatever reason. Second, it's his burden to establish standing, and he could have put on evidence at the hearing that show that it was not voluntary. He put on no evidence. In fact, Mr. Fuleki was not even at the hearing. Counsel provided argument after the state put on evidence, but he himself put on no evidence to establish his standing or that the waiver was involuntary.
But excuse me, that was loud. The petition, if he substantially complied in submission, is that sufficient? Just in a vacuum for pleading requirements to establish standing?
No. So the substantial compliance, that's 4111 subsection C, that applies only to the subsection B, which the district court priorly found that he complied with. And to be frank with Your Honors, that finding is not in the record. The state does not dispute that it happened, but I just can't give you details about what that specific finding was because it's not in the record. I looked in the Register of Action, the Public Access Portal. I couldn't find it. It's not trying to dodge the question. I just can't argue the details. But what the district court, when it struck its motion, specifically determined that he was not an owner or interest holder under subsection A, which the substantial compliance subsection does not apply to.
Okay. But let me just ask you then, at the hearing itself, I understand your position is that the claimant has some burden to make a showing of standing, but we're also looking at the district court's ruling on standing, which is supported primarily, if not exclusively, by the disclaimer form itself, correct?
It is primarily the disclaimer form. At the hearing, the district court also noted that coupled with his
statements.
His statements, but also the fact that his claim provides no assertion that he is an owner or interest holder. Those together show that he wasn't the owner or interest holder under the statute.
And if a claimant had an issue with the disclaimer form being considered by the district court, does a claimant have an obligation to contemporaneously object on the Fourth Amendment grounds, even if they had separately filed a suppression motion? Because this is a unique situation. If this was a jury trial, there might be one line of argument, but here we have a bench trial in a proceeding that I don't know how you would characterize it. It's not summary judgment. It's not a full-blown trial, but it's certainly an evidentiary hearing where there are findings made.
I would classify it as an evidentiary hearing, determine the voluntariness of the waiver. I think in this circumstance, yes, he needed to object. It might be different if the motion to suppress, which triggered the state's response for a motion to strike response, had actually argued that it wasn't, or that the waiver was involuntary. That might be different because that would have been part of the issue that brought it to the evidentiary hearing. But here where the challenge was to the searches and seizures, I think, yes, there was an obligation to object or to at least put on evidence to establish standing if Mr. Fuleki was not going to object to the voluntariness of the waiver.
And just to confirm on the record, it looked like there were two objections to the waiver, one for foundation and one under the best evidence rule. But I didn't see any other objections in the record. Is that your view of the record?
To my recollection, that is correct. I know there was no objection to voluntariness. Counsel, after the hearing, did argue that it was involuntary, but there was no objection during the hearing.
You're focusing on voluntariness and involuntariness, and that's what the judge was deciding. You're focused on that. But had a motion to suppress been granted, then wouldn't that whole issue about voluntariness or involuntariness become moot?
I don't believe so, Your Honor, because this was, the voluntariness and voluntariness came from the questioning of him later, not from the search and the suppression, search and seizure. If the issue was whether his statements when he was being stopped, where he said, that's not my suitcase, I don't have the key, things of that nature, if that had been what the district court relied on, then I would agree with Your Honor that the search or the motion to suppress, if it had been granted, could have addressed that issue. But when it's about his voluntary waiver that came during the questioning, no, I don't believe so.
So you're saying that he was at the police station, wasn't detained at the time he was taken to the police station?
He was detained, but the district court in its finding made findings, it likened this findings to Miranda and found the Miranda warnings, which he was given before they questioned him, and found that there was not coercive and that it was free and voluntary, the waiver was.
Okay, but he wouldn't have, if it would have been suppressed, he wouldn't have even been.
Well, he would have been at the police station because they took him there. I looked at I didn't find case law that stated that a police questioning you because evidence prior to it was suppressed is suppressed as well. Rather, he was at the police station. He chose to speak. Excuse me. He chose to speak with the police officers. They, like I said, they read him his Miranda warnings. He signed a waiver to him. He chose to engage with them. He was permitted.
Chose to engage, so you're saying that
He chose to speak.
he was detained, correct?
Right, and he had a right to remain silent, which was explained to him, and he chose to waive that right.
He couldn't leave until he, at least that's what the record said,
He couldn't leave until.
until he signed it.
That is not correct. They did not tell him he had to sign the form. They gave him the form. They told him he could sign. I see, Your Honor, that my time is up. May I finish?
Yeah, go ahead.
They told him, they gave him the form. They told him that he was not required to sign it. They did not threaten him with arrest or charging or promise not to charge him if he didn't sign or fill it out. They told him he could fill out whatever he would like to fill out. He chose to fill out the first part saying it wasn't his money. He filled out where he was coming from to where he was going.
But what I want to know is that, so you're saying as a matter of law, no fact here, as a matter of law, had the motion to suppress been granted, all of the things that happened, the evidence that was procured afterwards, the fruit of the poisonous tree, okay, you're saying as a matter of law, that would have come in.
I'm saying that the questioning, after he agreed to speak with the police, could come in. He could have challenged it, but he chose not to. He only challenged the stops, the two
But the
seizures.
stop, if you win on the stop, then the fruit of the poisonous tree. So why would you have to challenge all of that? Did he challenge, breaking the lock? Did he challenge bringing the dog? Did he, everything that happened after that, is a natural occurrence of the stop. So if the stop is thrown out as unconstitutional, right? Then why doesn't everything that comes after that?
If the stop were to be thrown out as unconstitutional, the stop, the seizures would be. But once he chose to waive his Miranda rights and decided to freely and voluntarily speak with the police, if you want to look at the fruit of the poisonous tree, that was an intervening act that I would think, it's an intervening act that would no longer apply that doctrine.
So someone who's detained wasn't allowed to leave the police station, correct?
He was not allowed to leave the police station.
Until he signed.
No, he wasn't allowed. I don't know what led them to allow him to leave the police station, but they never told him that he wasn't allowed to leave. Okay.
But everyone agrees he could not leave. When they asked him to sign this, he could not leave, correct?
At that time, he could not leave, no.
Okay, thank you.
If there are no further questions.
Any other questions, colleagues? Okay, thank you. And you reserve 3 minutes?
3 minutes, yes, Your Honor.
Thank you.
Good evening, Justices. May it please the Court. I'm Seth Crow. I'm appearing with Ms. Fuleki with respect to the $381,620,000 U.S. currency and Bryce Fuleki. Mr. Fuleki and the currency urge this Court to affirm and uphold the finding of the appellate court, which determined that the motion to suppress illegally obtained evidence in violation of the Fourth Amendment, and that it be suppressed, and that evidence obtained without a valid warrant or an exception to the warrantless search must have be excluded, and that hearing on the motion to suppress must have been conducted prior to the motion to strike Mr. Fuleki's claim to the U.S. currency. The district court initially, when this matter was brought before it at the pleading stage, did determine that he had standing. Then at the subsequent hearing on the motion to strike, the district court didn't allow the matter to go forward because of the voluntary disclaimer of interest, which for the record and on the record was not admitted to have been a voluntary statement. Fuleki contended that the statements that were obtained were not voluntary, that they were as a result of the unlawful search and seizure and detention, and that they should have been excluded as the fruit of the poisonous tree. And a little bit out of order for my argument, but to address one of the justice's questions earlier, during the course of the motion to strike hearing, the record is clear that Mr. Fuleki objected to the proceedings going forward, or terminating is a better term, without addressing his Fifth Amendment right to remain silent. Now,
that objection, if I may interrupt briefly, was on your Fifth Amendment challenge, right? But was there a separate objection at that evidentiary hearing based on the traffic stop itself?
There was so the way that Fuleki would argue his position was made at the time of the motion to strike, he said, well, the argument was that he objected on Fifth Amendment grounds to the introduction of the voluntary disclaimer of interest. That that should have been excluded based on Fifth Amendment grounds. And I'll come back to the statutory Fifth Amendment in a moment. I want to point out that the courts have held that motions to suppress are to be heard and can be heard in civil forfeiture proceedings. That's black letter law. That's U.S. Supreme Court case, 1 Plymouth Sedan. And to have not heard the motion to suppress beforehand, before the motion to strike the the opposition to the claim of forfeiture was error. And when the appellate court had an opportunity to discuss whether or not the proceedings should be held in the fashion that Fuleki argued was appropriate, and the appellate court, the Court of Appeals here, had to turn to the federal courts for guidance, and the federal court cases indicate that Mr. Fuleki should have had standing. He had a reasonable expectation of privacy in the vehicle. He had a possessory interest in the items in the vehicle. His claim form, contrary to the state's assertion, is clear that he asserts an interest in the property, and then he goes on to stand on his Fifth Amendment privileges with respect to the with respect to explaining the source of the funds, and he's entitled to do that. So if the statute is read as amended, and it needs to be amended, it needs to be read with substantial compliance, then Fuleki was entitled to make his claim of ownership, which he did. And then after he made his claim of ownership, he's entitled to stand on his Fifth Amendment privilege against self-incrimination. That's statutory, and I believe that it's appropriate to read 60-411A not in a vacuum.
Does that have anything to do with the disclaimer, though? The Fifth Amendment privilege you're describing?
Well, there's two. There's a statutory privilege, and then
either one. How does it relate to the disclaimer?
Well, okay. The disclaimer should not have been allowed to be introduced into evidence because it's a statement against his interest. He's voluntarily disclaiming an interest in the. He's allegedly voluntarily.
So if he had just told his neighbor, "I'm going to court tomorrow to claim an interest in this money, but it's not mine," let's say, and the state finds that witness and puts them on. Why can't they do that?
That hypothetical is not realistic, and it's not based on the facts of this case.
Well, I understand that, but the mere fact that the state has evidence that it wants to introduce that indicates that your client is not actually the owner of the money, I just fail to see how any kind of Fifth Amendment, whether constitutional or statutory privilege against self-incrimination, could prevent the state from introducing independent evidence of non-ownership.
But it's not independent ownership it's not independent evidence of non-ownership. It's evidence obtained after an unlawful search and seizure.
Your real objection, sorry to interrupt, your real objection, it seems to me, correct me if I'm wrong, is that the introduction of the disclaimer as evidence would violate the Fourth Amendment. It would violate or let me put it a different way, it should be suppressed under the exclusionary rule as fruit of the poisonous tree. That's the real argument against the disclaimer, right?
That is a very valid argument against the disclaimer.
It seems to me maybe, I wonder if we're making this case way more complicated than it needs to be. This is, again, correct me if I'm wrong, it strikes me that This is all about whether or not that disclaimer can be properly admitted as evidence. Would you agree with that?
I would concur.
And your claim is simply, look, we never got a chance to argue a real objection to the introduction of this evidence on Fourth Amendment grounds. Is that fair?
That is true.
And then I guess my follow-up, and I think Justice Wall was hinting at this as well, was that objection made at the hearing
It was.
on Fourth Amendment grounds?
Yes.
Okay. And that's in the record. It was made contemporaneously when the state wanted to introduce it.
Correct.
Okay.
And I don't want to make it more complicated than it is. And you have in my moving papers the analysis of U.S. coin and currency. And U.S. coin and currency is a Fifth Amendment case which discusses the introduction of the gambler argued that his tax returns couldn't be introduced in order to convict him on Fifth Amendment grounds. And the Supreme Court upheld that. And I see similarities, and I would like the court to see the similarities on Fifth Amendment grounds. The fourth, and because that disclaimer is really the only evidence in this case, it should also be excluded. I also would like to point out, I want the court to read 60-411 in all of its subsections to stop an analysis, as the state argues, at subsection A is, the Latin term is para materiae. It's basically beheading the statute and disregarding the reasons for why the amendments were done in the first place. So because substantial compliance should be enough. And what the error on the district court's part was, the district court allowed in statements which were violative of the Fourth Amendment, additionally violative of the Fifth Amendment, in order to grant the state's motion to dismiss. And if the court had allowed the Fifth Amendment privilege to stand, those statements would not have come in. There wasn't any other independent evidence of well, I'll withdraw that.
No, your argument, as I understand it, is that, assertion of the Fifth Amendment privilege in conjunction with a general statement of an interest in the property is sufficient, but that's only sufficient, not conclusive, correct? Because at some point, a district court judge is going to have to hear the evidence and decide whether or not, who gets this property, who does have interest. So weren't we at that stage at the hearing?
No, we didn't get to it. It was, the error of the district court was when the district court determined there was a loss of standing. The district court should have allowed the initial opposition to forfeiture, which gave a statement of ownership. It should have been combined with the possessory. You have the possessory interest in the money. He's the only person who has the money in the vehicle, and so he can assert his Fifth Amendment privilege statutorily, and then at that point, the court should allow the motion to suppress to go forward. But instead, the court didn't allow the Fifth Amendment privilege. The court allowed the involuntary disclaimer but it was a statement against his interests. So it wasn't so much whether it should have been allowed in, it was when. We were in the discovery case of the case, the discovery phase of the case when the motion to suppress was brought. And the case should have been allowed to proceed to the motion to suppress as opposed to essentially being cut off in the discovery phase. And that's what happened here. And the line of cases that support that are substantial, primarily. One other point I want to make, just while I have a moment, is the court hasn't asked any questions about being an interest holder or owner or interest holder. And I think it's important to point out that Fuleki did establish, I think that's what Justice Steele was driving at. How could he could just come in and say he's, the owner. $381,000 on the table, I might as well try and grab it. That's not what happened. He had to establish that his interest was legitimate, and he would have been able to do that if the claim had proceeded past that point, or alternatively, there would have been no evidence to have been introduced if the motion to suppress had been granted. He would have had enough evidence to carry his burden that he was the possessor just based on having a possessory interest. The KSA statutes have adopted the UCC. The UCC indicates that it's enough to, for cash, for money, to be an owner or interest holder if you have a possessory interest. And there's no dispute that the money was in the vehicle. He's the only person who possessed the vehicle, thus he would have had a possessory interest. And that refutes the state's position that he was not. I see my time is about to be up. Any questions from the court?
Any more questions, colleagues? Okay.
Thank you for your time.
Thank you, Mr. Krell. You reserve 3 minutes.
May it please the court, I'm going to begin where Mr. Krell ended, and that is Fuleki never established any ownership or possessory interest. His claim and his amended claim, if you look, they both say, I claim an interest, not I own it, not a possessory interest, which is defined by statute, a specific thing under the statute. Just, I claim an interest. It's very bare bones, it's basic.
Why isn't that enough to get you in court? I claim an interest.
Because the statute requires them to be an owner or an interest holder.
Well, he would have an evidentiary burden as a case proceeded, but to initiate a case, that's all that's required, is to say, hey, that's my money, right?
One quick point of order is that he's, of course, not initiating the case. The state initiated the case here. I just wanted to make sure
But
we
he
weren't.
steps in and says,
Yes.
that's my money,
He does.
effectively.
I would disagree. He steps in and says, I claim an interest.
What's the difference between those two?
Well,
I claim an interest and that's my money.
I think there's a variety of ways to interest. What I would argue here is at best he was a bailee, which does not qualify an owner or as an owner and interest holder. I would call him a bailee by the fact that that suit, while it was in his rental car or the rental car he was driving, and
Again, you have a little bit of time, so sorry to interrupt, but
No, you're
those are all the factual nuances that are supposed to get resolved by the fact finder after receiving evidence, right? You don't resolve those factual distinctions, the fine distinctions at the beginning of a case. You have to hear evidence, right?
And the district court did hear evidence here on this matter, Your Honor.
And I'll come back to maybe the very first question I asked. Is it true that in the record of this case, the district court never made a finding one way or the other about whether or not this evidence, the disclaimer, was either admissible or not admissible under a fruit of the poisonous tree theory?
No, Your Honor, its finding was based off of it being knowing and voluntary.
Okay, so I just want to cut to the chase, because I do agree with Justice Stiegel that we may be overcomplicating it. The district court said there's a voluntary disclaimer, so therefore you have no ownership, so therefore you have no standing, and therefore you don't have standing for a suppression hearing, right?
The district court, I agree with you up until the last point. The district court said you have no standing, so I'm striking your claim. And then the necessary consequences of that is that there's no suppression motion to hear. But other than that, I agree with that, Your Honor.
Okay, but isn't the correct order supposed to be, is there a Fourth Amendment violation? If yes, is the disclaimer tainted? If tainted, the disclaimer can't defeat standing. So in other words, the district court erred because it resolved a statutory standing issue using evidence whose admissibility depended on unresolved Fourth Amendment issue.
Your Honor, my time is up. May I
Yes.
respond? The correct order is that standing is decided first.
Why?
Because standing is subject matter jurisdiction. You must have
So
standing.
this is statutory standing. This isn't,
Standing consists of constitutional and statutory standing, but they're both required. You're required to have both to participate in a case.
but to resolve the standing issue, then he went and made a finding that it was a voluntary disclaimer. How
Yes.
can you rely on evidence that may not be admissible to make a standing finding? That's just backward.
The district court heard evidence about the voluntariness of the disclaimer. He made a standing finding. If Mr. Fuleki had wanted to argue and put on evidence that it was fruit of the poisonous tree, yes, it would also be part of the suppression hearing, but
Wasn't allowed to.
he could put on evidence as to the voluntary disclaimer. He chose not to. It's his burden to establish standing.
His evidence he wanted to put on was that the evidence was inadmissible, okay, because there was Fourth Amendment violation. Why can't he argue?
He could have at trial if he had wanted to, but he chose not to. And after the state put on their evidence to the voluntariness, he could have responded. He chose to put on no evidence. The district court did not forbid him from putting on any evidence at the standing hearing. The district court stated we're going to address the standing issue. If I find that there is standing, then we will address the suppression issue. If Mr. Fuleki had wanted to put on evidence to show that it was involuntary and therefore it shouldn't count to find that he lacked standing, he had the opportunity to, he chose not to.
Okay, so this is from the transcript, but nevertheless, claimant would argue that for the court to fail to provide Mr. Fuleki an opportunity to bring his motion to suppress before the court is to deprive him of his constitutional rights under the Fourth Amendment.
If I
So
recall,
that was, discussed. That's what they wanted.
if I recall correctly, that is Mr. Flecky's attorney's arguments. The district court, I don't recall the district court telling him he could not put on any evidence to establish involuntariness.
He's not trying to establish involuntariness. It goes to admissibility.
He didn't put on any evidence whatsoever. It was his burden to show standing. He chose to put on no evidence. He argued against it. He argued it was involuntary
I
after.
think we're kind of close.
That's fair, Your Honor.
Thank you.
You're welcome. If there's if there's no further
Colleagues,
questions.
any more questions? from the state? None. Thank
Thank
you
you.
very much. for
Thank you, Your
arguments
Honors.
tonight. That concludes this evening's docket.